Hi, it's Jessica with Leverage Legal Group. I have a lot of clients that get confused by this. They think that because they registered their business name with their state, maybe they formed an LLC or a corporation, that they own the business name as a trademark. And that's not exactly true. So let me clarify. Here's the truth. Your state business registration only protects you inside that state's database. And also, it doesn't give you any trademark rights. There are two different databases. There is a trademark database within the state, and there is the entity formation database where they have all the entity names, and they are not the same. So if you go to set up an LLC, for example, and it looks like a name is available to you, all that means is no one in your state has chosen the identical name that you're using. And so the state's going to let you use that as your business name. It does not mean that they've done any research, they've cleared it for you, that it means it's available to use as a trademark. State business registration only protects you within that state's entity database. And also, it does not stop someone else in another state or even in your own from trademarking the exact name at the federal level and locking you out of it. And yes, that means you could be forced to change your name, even your domain, your logo, social handles, all your branding, packaging, depending on what you're using for your name. So let's break down the difference between a business name and a trademark and why it matters so much for founders and how to make sure that you actually own your brand. So what your state registration does and doesn't do for you. So when you register an LLC or a corporation, you're creating a legal entity. You are not protecting a brand name. That filing simply prevents another company in your state from registering the exact same name in that state's corporate registry. So it gives you permission to operate under that name locally. It gives you the right to open a bank account, and it gives you the ability to file taxes under that name. But it gives you zero exclusive branding rights. So if a business in another state, or worse, one with a federal trademark, starts using the same or similar name, or they were already using it, they can claim that you're infringing on their mark, even if your LLC was filed before they started using the name, but particularly if your LLC was filed after they started using it. So estate filing is basically a business license to use the name. It is not brand ownership. So let's talk about what trademark actually is. A trademark is completely different. It is what legally protects your brand, your business name, logo, maybe tagline or slogan, even product names in connection with the goods or services you sell. So when you think of trademarks, I like to think of like Starbucks, for example, is a good example. So they have an overall trade name, or sometimes you will call it a house mark, which is the name Starbucks coffee, and then the mermaid logo, that green emblem. Those are the two big source identifiers for their entire brand empire. Then they also have product names that are trademarked, like Frappuccino. You can have trademarks in your main brand name. You can have a logo for your main brand name. You can also have trademarks for products or services or various other types of branding in your business. Anything that you want to own exclusively and have it be associated with your company as a source identifier can be protected as a trademark. Even packaging, even colors, like Tiffany's has the color blue, Mattel has their color pink trademarked. Even smells, Play-Doh has their smell trademarked. And sounds, like Intel, bum, 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 is a source identifier. That is something you could trademark. So any of those things that are source identifiers used in connection with the goods or the services you sell is a trademark. And trademarks actually exist to prevent customer confusion. So when customers see your brand, the law wants them to know who's behind it. They want consumers to be able to know for sure who they're doing business with. A federal trademark registration is with the United States Patent and Trademark Office, also known as the USPTO, sometimes also referred to as the PTO. And this gives you nationwide exclusive rights to use the mark for your specific goods and services. It also gives you the power to stop others from using confusingly similar names, not just identical ones, but ones that are confusingly similar to yours anywhere in the United States, not just in your state. Now, this is limited, obviously, to the category of goods and services that you're offering or your industry. So if there's a company in Michigan that wants to launch Starbucks tires, they might be able to do that because no one would probably ever believe that Starbucks tires was associated with Starbucks coffee. Now, Starbucks is a famous mark, so they still might not be able to use it. That's a whole other conversation. But generally, trademarks are looked at specifically within your industry and with respect to the specific goods and services that you are offering under that mark. But within that realm, a registered trademark gives you the power to stop others from using confusingly similar names anywhere in the US. So again, it's not just state-based. And it gives you the right to send out cease and desist letters to people that you believe are infringing and to file lawsuits, to get injunctions against other people who are, using your mark or one that's confusingly similar without your authorization. You can even take down listings on places like Amazon, Etsy, Instagram, Shopify, etc. And having a registered trademark gives you a public record showing everyone else, the rest of the world, that you own it exclusively, which hopefully will be a deterrent from people who might otherwise infringe on your rights knowingly or unknowingly. So a trademark equals exclusive brand ownership plus national protection plus the legal remedies you need to enforce your rights. Now, if you don't have federal registration, your protection is under what's called common law trademark. And common law trademark does give you some protection, but it generally only covers a small geographic area where you actually use the mark in commerce. So it's basically your current customer footprint, and it's never going to give you national rights the way that a federal trademark does. Now, if you expanded nationally and have locations all over the country, maybe you have some broader protection, but it still doesn't give you the legal remedies that federal registration does. So that is risky to rely on that in today's digital world, where your audience and your competitors are literally everywhere, particularly online. So let me give you a real world scenario that I've seen more than once. Let's just do sort of a hypothetical. Say there's a founder in California who built a great business called Blue Leaf Design Co. And she's been using that name for 5 years. The LLC's filed, the website is up, she's got a huge amount of followers. She's making great sales. And then one day she gets a cease and desist from a company in Texas that owned the federal trademark registration in Blue Leaf Design. So hers is Blue Leaf Design Co. And the company that has the federal registration is Blue Leaf Design. So even though she's been using the name longer in her state, the Texas company's federal registration gave it nationwide priority. So she had two options. She could fight an expensive legal battle or rebrand her entire company. And she ended up spending months and tens of thousands of dollars redoing everything, all because she never registered her own mark. Federal registration is going to beat state registration most of the time. I want to explain something about that. Trademark rights in the US is based on who used the mark in commerce first. So use in commerce is defined as basically offering goods or services for sale across state lines. And that is really the standard. There are other scenarios like transporting goods across state lines or internationally can also put you in commerce. But generally, for most of us in the US, are you offering your goods or services for sale across state lines? Now, if you have a website, then you are probably in commerce because people from anywhere can purchase from you. So whoever uses the mark in commerce first has what are called priority rights or senior rights in that trademark. So say that Texas company, Blue Leaf Design, was not using it first. Say this person in California with Blue Leaf Design Co. was actually the one using it first, but she was just using it in California. Who has priority rights? Well, we have to look to see who is using it in commerce. That's the standard for federal protection. So you want to be the one using it in commerce first. If you were not the one using it in commerce first, then you are not going to have those senior rights. It's the company that was using it in commerce or across state lines first. That's what we're looking for. And then if you were using it in commerce first and you got federal registration, then you absolutely have priority rights against everyone else in the US. And that's really what you want to have. So if this person in California didn't have that use in commerce, and then this other company did and also got federal registration, that is going to trump state use every time. So here's why I tell my founders, always don't just form your entity, your LLC or your corporation. You must, right after you do that, you want to file for federal registration. So let's talk about the benefits of federal registration for your trademark. When you register your trademark federally, here are the 5 things that you're going to get as a benefit. Number 1, you're going to get exclusive ownership across all 50 states. Number 2, you're going to get a presumption of validity. Courts will automatically assume you own it until proven otherwise. Now, it can be proven otherwise, but you get an assumption initially that helps you in those types of disputes. Number 3, you get powerful enforcement tools. These are the remedies that I mentioned earlier, the legal remedies that give you the ability to stop infringers quickly through injunctions and also to recover money damages from their unauthorized use of a mark that was either identical to or confusingly similar to your trademark. It also gives you nationwide notice. Your mark is searchable. It's easy to find from the trademark database, and so others will know not to use it. And it gives you a valuable asset. In fact, it's going to become the most valuable asset in your business. It is what people will begin to associate with the experience of doing business with you, the quality of your services or goods, the customer experience, and maybe there's even a tribal element. You think of companies like Disney or Apple begin to have a tribal element association with the brand that is extremely valuable. That's called the goodwill of your brand. And for big companies, that trademark and the associated goodwill and reputation become one of the most valuable assets of a business. And with that asset, you can license it, you can sell it, you can use it to attract investors, to do collaborations. And so these are incredible assets in your business. So when it's registered, you have access to all of these things. So federal registration paves the way for you to turn your brand into the most valuable asset in your business. Now, let me just ask you, as a last thing to discuss today, how do you know if you can trademark your business name? So before you file, you need to know that your name is actually available and that it's protectable. And that is where trademark clearance searches come in. As a trademark lawyer, I do very detailed research, both with the federal trademark database and other sources to find potentially conflicting marks, including spelling variations, sound alikes, similar meanings. And this is very important. We're looking for marks that might be deemed confusingly similar by consumers. A proper search and legal analysis can save you from investing in a brand that you can't actually own. And these are things you need to find out right at the outset when you're launching your business, ideally, because you don't want to pick a name that is one that is infringing on somebody else's or is one that you can't own exclusively. So search and have a good trademark lawyer help you figure this out before you spend a bunch of money on branding and marketing your business. Now, let me just say as a last thought, if you have already been operating and you did not do these things, it is still better to spend the time and money to work with an experienced trademark lawyer now before you get hit with a cease and desist letter. And so it's never too late to do this work. Now is always better, regardless of how far you are in your business. And so do it while you can do it in a strategic posture, not a reactionary and defensive one. So if you've built a brand you love, don't lose it because you stopped at an LLC or corporate filing. I help founders and business owners secure their federal trademarks and make sure they have a strong trademark so that no one else can profit from your name, your logo, and the goodwill that you're developing in your business, your reputation. So if you're concerned about these things and you haven't taken care of it yet, just give me a call. We can do a free consultation call and I can work with you to check your brand, identify that there, whether there are risks, and help you get the protections in place you need before someone else beats you to it. Just schedule a call with me and let's make sure that your business name isn't just registered, but it's something that you can own exclusively and it's protected.